Divine.
Okay.
We bring her up on the stage.
That's right. We're going to bring her up on the stage. It's official right now that we are live.
Live.
Yes.
Yes.
A little
I'm gonna just
after
repeat everything you said.
8:05. We are going to, I'm going to invite Divine to come join us.
Divine is divine. Let's see. I think
Divine
can we turn that down? Your volume all the way down?
Turn it all the way down. All right.
All right.
Yep. We have Divine on TikTok
Let's
now.
let's wait a couple minutes. Oopsie daisy.
Everyone,
right. Check out the beautiful sky behind us. Let me see. Can you see that?
Oh yeah, look at that. That is not water. We're not underwater. We're not in an aquarium.
Just it is the sunset happening behind us as we speak.
Okay, we are live. We're looking to let people start to load up here on TikTok.
Let me share this.
Facebook Live and on YouTube. Welcome everyone. How's everyone doing out there? My name is John Gardner. This is my wife and law partner, Radlin Mendoza. We are co-founders of the immigration law firm Gardner and Mendoza. And we come to you every Wednesday at 8 o'clock. And recently, we've been coming to you every Wednesday at 8 o'clock with the addition of our guest, Odette Batchelor, who is retired senior USCIS immigration officer. She's become a regular guest on our live. So Odette, thank you so much for joining us again. Always a pleasure to have you.
Hello, Odette.
Hello.
We always pick a topic. Tonight we're going to talk about the June 2026 Visa Bulletin, but we also answer your questions. If they are related to the topic that we're covering, they'll take priority. But if you have a question that's about something completely different, but it's still immigration related, go ahead and post it up either in Facebook or on TikTok, and we will absolutely try to get to it. I do want to warn you that what we do here is for informational and educational and even sometimes entertainment purposes only, but it's not legal advice. Okay, folks? We're getting small snippets. I mean, we're three very well-versed folks in this topic.
And I'm still sharing, sorry, keep going.
But you know, when we're dealing with a small snippet of information, we cannot give you legal advice on that. If you become a client of ours, obviously we will do a very, very deep dive into your case. We will turn every stone over. We'll cross every T, dot every I. We'll have a retired senior USCIS immigration officer give you mock interview if you like. I mean, we'll do it all. All righty. So, all right.
Welcome.
With all of that,
let's talk about the topic.
Yeah, let's talk about the topic.
Talk about the topic. So the topic in this scenario is you are a lawful permanent resident and your spouse and or your children are here visiting you in the United States, or maybe they're about to come to the United States. And guess what, guys? Great news. The June 2026 Visa Bulletin is current for filing for June 2026 in the F2A category. So what that means is that if you're a lawful permanent resident and your spouse and or your children are here visiting, your unmarried children under the age of 21, want to make sure that we distinguish that from married children or children over the age of 21. But if they're here visiting and they're here in June, or maybe they're coming, the dates for filing are current right now for the F2A category. So they can potentially be eligible for adjustment of status. And we were just talking about this with Odette before we got started here. And this is a really great, wonderful opportunity. But there are certain, I'm going to say, things that you need to be mindful of and be aware of. Very, very important. And I would say for lawful permanent resident spouses, that important thing to be aware of is your intent, right? So Odette, if you can kind of expand on that a little bit. So let me give you a hypothetical here. It's May 1st of 2026, and you are coming into the United States, let's just say from the Philippines, to visit your husband. All right. Maybe you all just got married a few months before, but this is your second or third trip to the United States to see him. And he was your boyfriend and then your fiance. Now he's your husband. You guys got married in the Philippines. And it's May 1, 2026. We don't know anything about the June Visa Bulletin. Okay. She doesn't know about the June Visa Bulletin. He doesn't know about the Visa Bulletin in June. We don't know about the June Visa Bulletin in the F2A category. Immigration officers don't know about the Visa Bulletin being current. So what is the scenario there? They're coming in, and what would you say about intent here?
Well, the first thing, say for instance, they did file this application, and we want to know, did you already have in mind that you were going to come here to the United States, file an application to stay here, to circumvent consular processing, to just adjust your status in the United States instead of doing it overseas? And there's some people that do have the intent of going back. So if they were going back, show us that you were going back. Do you have a plane ticket? You know, do you have your flight reservations? Do you have all the things that show, like a job back in the Philippines, to show that you're going back to? That would show that you never had the intent to come here and stay. You were just coming to visit in the first place. And so they'll ask these type of questions. And hey, we didn't know the Visa Bulletin was available. Okay, well, that's good, because hey, you came in May. The Visa Bulletin doesn't come out to the end of May, towards the middle to the end. So right there just shows right there that they're probably telling the truth.
They're probably telling the truth.
Probably
right?
telling the truth. Yeah.
Okay,
So more likely than not telling the truth.
your intent
Yes,
time you enter matters then.
it does matter.
It
Yeah.
sure does. Okay.
Okay, so what if, let's change the scenario around a little bit. What if they were coming, that she was coming, this is his wife, lawful permanent resident wife. For those of you just joining us, this is a hypothetical of, yeah, you're a lawful permanent resident in the United States. Your new wife is coming to visit you from the Philippines, and we're talking about what are we going to say and what is our intent, right? What is our intent about, what is her intent when she comes into the United States? So let's change it around a little bit. Let's say that she is coming and she has, 3 boxes, 4 boxes. And she's coming and all the boxes are filled up with her clothes. Okay. And she has her birth certificate, her vaccination records. She just quit her job 3 weeks before she came into the United States. And she does have an open ticket. So it is a return ticket, it's an open ticket. Okay. Now, she is asked at the port of entry, what's the purpose of your trip? And she says, I'm coming to see my sister. And that's what I'm doing here. I'm coming to see my sister. And she did have a ring, and she had an engagement ring, and she had a wedding band, but she removed it before she came to the airport. What do you say about that? And then they filed for adjustment of status. What are your thoughts on that? If some of that comes out during the interview.
If that comes out during the interview, that just shows to me that their intent was never to come just to visit. Rather, they visit the sister, the husband, maybe everybody lives in the same area. They could have been coming to visit the sister, but they never had the intent to go back. You came with your belongings, you came with an open ticket, you didn't tell the whole truth at the port of entry.
Right.
So that intent shows right there that you gave false information coming in.
Okay, so you're going to equate that, and again, guys, we have senior immigration officer, worked for USCIS and INS for 42 years. She has looked at tens of thousands of applications and made decisions on tens of thousands of applications. And our team has been doing it, in total for 26 years. We haven't looked at tens of thousands of applications. Not like maybe 100,000. I don't know. Lots and lots, right? Lots and lots. So Odette is giving us her perspective as a retired senior immigration officer. And, you know, the facts that we've posed here are pretty extreme. I mean, you know,
Right.
like I made it extreme on purpose. But when Odette is hearing as an immigration officer, former immigration officer, that you had all this stuff, you quit your job, you didn't have a return ticket, you had an open ticket, we're going to just assume what I'm hearing from you, we're going to assume that you made a misrepresentation. See, immigration lawyers like to call it a misrepresentation. Immigration officers like to call it a lie and fraud, right?
Circumventing the immigration law.
Yeah.
Right. Circumventing the immigration law. So that's a problem. That is an issue. We, you know, how do we fix this? We would have to file a waiver, right, for the misrepresentation, and that's, we have to show extreme hardship to the lawful permanent resident spouse, if we even have get the time to do that these days, and that's going to be decided upon by the immigration officer, right, who you may or may not have tried to circumvent the immigration law, right? So Odette, have you ever had that scenario happen where
I have.
yeah, tell us about the scenario, because the reason why we're talking about this is because this F2A visa bulletin is current, and yes, we're all excited about that. But when we talk to you as immigration attorneys, we're gonna go over, what did you tell every single time I talk to someone, what did you tell the port of entry officer, the CBP officer? What did you tell them when they came in? What did they ask you? What questions did they ask you? So obviously, the fewer questions, the better, right? Sometimes that's the case. If there are no questions, there are no lies, right? Or misrepresentations.
There you
So
go.
Odette, tell us about a case where you had that would fit under this scenario here.
It was he was very open about it. He filed for he waited until his wife came to the United States, filed the I-130 45. The wife came in as a visitor, and they filed like literally the same week. By the time they came in for interview, looking at the dates of the application, the first question is, if you just came in on a visitor's visa, do you have children? Oh, yes, my kids came with me to visit my husband. Okay, well, do you have a home back in your country? Are you going back home? Do you have a job? And the husband just was like, I'll just be honest and say, no, we're not waiting that long for a visa at the National Visa Center. We want to get our stuff done now, and we're going to file here in the US. And that's what he said. He said, we don't have time to wait. So that led to his letter and moved on from there.
Okay, so you mean, are you talking about letter of denial, or are we talking about
we gave him a chance to file a waiver or a recommendation. So we gave him an intent to deny. He came back in writing and said the same exact thing. So I guess he didn't care. That led to a denial, which led her to be in proceedings in court.
Oh,
yeah. Oh, so, and you don't want to go that far.
Okay, guys. So
did
you see our reaction when we said removal proceedings? So, this is terrible. So, notice of intent tonight. Can you tell our wonderful viewers what is the NOID and how much time do you have to respond to a NOID?
Well, that NOID is a notice of intent to deny. We'll go over in that letter exactly what the interview was about, what you said, and you have 30 days to resolve anything or to file maybe a waiver if there was a chance to file the waiver. If you come back with no real proof that, no, that's not what you meant, this is what really happened, here's my ticket, then okay, we'll look at the waiver and see, well, you did say in the interview. And a lot of times these interviews are recorded. So you can't go back and say you didn't know. So that's another thing to think about.
That's what I was going to say. I was going to say, I mean, you can't say that now. You said something completely different 30 days ago, right?
Right.
I mean, you can't go back and say, well, no, I was actually totally going back. Now you're putting a lie on top of a lie,
Right.
or maybe not a lie. Maybe he told the truth. So, folks, annoyed, notice of intent to deny, you have 30 days to respond to that. That's not enough time for an immigration attorney to step in and file a waiver,
Right.
right? I mean, a waiver takes a lot to prepare. There are a lot. It's very fact specific, and so we have to prove extreme hardship to the lawful permanent resident or the U.S. citizen petitioner, and we're talking about medical hardship, emotional hardship, as well as any type of physical hardship. And 30 days is not a lot of time. By the time I was going to say, realize. Okay, the right word is realize instead of what I was going to say, which was not. By the time you realize that, oh my gosh, I probably should have a lawyer. You're like 3 weeks in, and that thing is due by next week. So be really careful about that. We're not trying to scare lawful permanent residents who are on the road to filing a petition and filing green card application for their spouse or children if they are here in the United States. And you can do that in the month of June, because the Visa Bulletin is current for dates for filing, which means if you're in the United States, you can file adjustment of status. You can file the petition and adjustment of status. Maybe the petition is already filed. You can marry those together, and this is a great opportunity to really bypass these long wait times for the I-130, right? I mean, you do consular processing for I-130, those are taking a really long time. They're taking way more than 17 months. And so this is a wonderful opportunity. You just have to be careful about how you do it. And please, please, please hire an immigration attorney. We obviously would prefer if you called us and hired us, but there are many reputable immigration attorneys out there. You just need to find one ASAP if this is something that you are thinking about doing. Okay, let's grab some questions here.
Yeah, that's just a reminder. I just wanted to add that just as a good reminder here that, the intent has to match the visa for coming in. So, if you say you're coming here to be a student, but you actually have no intent to be a student, and second you get here on the student visa, you go do something else, that's not what the visa was for. So be careful that your intent matches the visa, and also be careful that your dogs are not loose in your studio when you're live.
Did you hear the dog barking, Odette?
Yes. Did you hear mine?
It was not our dogs. It was Odette's
Your
dogs.
dog was probably looking at our dogs.
No, that's a great point. Can I just say something about that? And this is actually
I'm going to add a caveat to that. But yes.
Okay. This has actually happened in an interview where I don't know if it was you, but one of the first times I heard this question, young lawyer. I was a young lawyer. And the officer said, well, did you go to school? No, I did not go to school. So you came in on the F1 visa, the student visa, but you didn't go to school. No, sir. I was just like, okay, Radlin, you probably should have asked your client if he went to school. Guys who are listening right now, I was 27 years old. That was 27 years ago.
We have had people who said, oh, yes, here's my I-20. The I-20 doesn't prove that you went to school. It just proves that you were accepted and you paid your fee to get this far. It doesn't mean you actually went. So people will try to produce an I-20 too.
Well, what were you going to add on to that?
Yeah, so the intent matters at the time you enter. Now, that said, circumstances can change once you're here. And if your circumstances change, that's a different story for a different day. But for purposes of tonight, just make sure that your intent is true and matches what you're saying you came here for and what you were granted a visa to come here for.
Right. Absolutely. And I will just hop on that change circumstance, because
Different
I
story, but for tonight, not another night. I'll go with it. Go ahead.
well, that's why I said hop on, because I was gonna hop on, hop off. Like
No,
it
no,
was
I
like the
love it.
hop on, hop off New York City bus, you know.
No, go for it. Go for it.
So I always say, look, if I'm talking to a couple and they don't know anything about immigration, right? And here usually it's going to be a U.S. citizen doing something for their girlfriend or their boyfriend, and they're there for information gathering, right? That the person has a job back in their country, the person has a return ticket, the person is going back next week. But if I, as an immigration attorney, explain to them some of the things that they can do because they didn't have this intent, then that is a changed circumstances in my mind. It's like, look, tell the immigration officer when did I know? I knew when I talked to that immigration lawyer, right? And that's when I thought, I didn't know this was an opportunity for me to do this. So what do you think about that, Odette? I'm just trying to do some pre-adjudication here.
Intent was honest. Your intent was
Intent was
true.
honest. What
The
are your
intent
thoughts?
was honest. Well, I think we would ask more questions
Yeah.
to ensure that, and just look at everything else that they have that they provide with their application,
Okay.
and it's a possibility.
Yeah. I had the craziest I had the craziest case, and the couple basically they called the 1-800 number, right? The US citizen husband called the 1-800 number. And the 1-800 number, I'm pretty sure, is still manned by contractors, right?
Yes.
Yes. So they're contractors, they have training. You know, during that time, it was a long time ago. It probably wasn't the best training. It may still not be the best training. Who knows? The contractors are going to know. Tell your wife to come to the United States. She can just use her ESTA visa, her ESTA, not a visa, but she can just use her ESTA, come in, and you guys should just get married and then file your paperwork. And literally, that was the advice given to them by the contractor, the USCIS contractor. That's exactly what they did. And then they came to me and they said, these are the circumstances. And I was like, oh man. And they were the wife was not asked any questions at all at the port of entry. So no misrepresentation. We filed the case, and we submitted affidavits about how this was their intent, but it was they thought it was something that they were able to do based on the information that was given to them. I mean, thankfully the cases got approved, but that could have gone either way, really, because of the intent. But I'm such a great lawyer that it got approved.
That's good.
I was waiting for the delay in the laugh there.
We have a question on Facebook. We have an odd situation tonight that I don't think I've ever seen. We've got all these people on TikTok like we always do, but no questions.
No questions.
Shocking.
Okay, that's okay. Well, if we have a question, we have a question here from Carolyn Kelly.
You folks on TikTok, if you missed the introduction, if you have questions, go ahead and put them in, and we'll try to get to them.
Well, it's 8:30. We should probably reintroduce ourselves.
That's right. For those of you who are just joining us, my name is John Gardner. This is my wife and law partner, Radlin Mendoza, and we are the co-founders of the immigration law firm Gardner and Mendoza. Celebrating our 25th law firm anniversary.
It's 25 plus 1. Yeah, last year.
It's 26.
It's 26 now.
26th year now.
Yes.
So, and we have a very special guest with us, as we do often now, which is very exciting. Odette Batchelor, who is retired senior USCIS immigration officer. She brings a ton of wisdom, information, inside baseball, unique perspective, other side of the desk, all the things that everybody's dying to know, which is, what are the officers actually thinking? What are they actually looking for? What are the red flags that they're spotting?
Yes.
And so great opportunity. If you've got questions, now is the time, or you can just call us and schedule a consultation with our law firm. Then you can ask tons of questions.
Yes, 757-464-9224. We are located in Virginia Beach, Virginia. We serve all 50 states and around the world as an immigration law firm. Okay, let's grab this question from Caroline. She says,
There's a lot there.
all right. We submitted my baby document with USCIS around the 23rd of September, 2025, and we're still waiting. How long do we have to wait? My baby was born outside of the United States. My baby did not have any visa when we came in, but her travel documents from consular in foreign country. What did we file with USCIS? Did we file an I-130, I-45? Caroline, I'm not sure what you filed. Odette, what do you think? We've got travel documents from consular in foreign countries. So
If she have a travel document, I want to say if she's a U.S. citizen, they would have automatically given her the NA3 visa for the child, but I don't know the whole story.
Right. Yes, we don't know the whole story. And this is why it can't be legal advice. We don't want to make any calls on just very limited information here. To me, it sounds like this baby did not enter the United States with any type of visa, right? Because they're foreign country consular travel documents from the way that I'm reading that. And so we're not sure.
Yeah. Don't know.
Because even if your baby did derive citizenship from you, the baby would still have to enter the United States with inspection. So give us a call. We love solving problems like this. Caroline, thank you for the question. All right.
Okay, we finally have a question. We got like hundreds of people on TikTok, and none of them have asked a question.
That's okay. Don't be shy.
Again, I'm sorry. I'm just the one kind of like, wow, because we've been doing this for many, many years. And normally they're just, not only are there a lot of questions, but usually the people post the questions like 20 times in a row. Anyway, we finally have a question here. Hi, we submitted our I-130 case in 2023 and haven't heard back since then. What should we do?
Well, I mean, what was the I-130 for? Whom was it for? I mean, if it was submitted, an I-130 was submitted in 2023 for, say, a sibling, you can't do anything, unfortunately, other than wait. That's going to take 4 or 5 years for USCIS to approve. If you are a lawful permanent resident and you submit it on behalf of your spouse or unmarried child under the age of 21, that's also going to take 2+ years. If you submitted it for your spouse and you are a U.S. citizen, that's taking about 18 months right now. So I would say it's probably outside of the processing time. If you've filed it in January of 2023, 18 months would have been July of 2024. Did I do the math right there? So it really depends on who that petition is for. And it sounds like you filed it and it's consular processing, because otherwise you would have said adjustment of status, but there may not be anything at all wrong with it. If you got a receipt, right? If you got a receipt for that, then you can check your receipt and see online and see what the case status says. Got anything to add to that, Odette? This is
No, you covered all of it. But it kind of sounds like maybe they haven't heard anything back. So hopefully they did get a receipt. I'm not sure, but if they did, yes, the only thing you can do is check that.
Right. I mean, if you didn't hear anything back, then yes, there is a problem.
Right. And I would definitely see if the check was cash.
Right.
She said me and my spouse.
Yeah. So hopefully you got a receipt. Now, if you and your spouse, if you filed an I-130 petition for your spouse, and this is a big mistake that people make when they're self-filing, if you filed an I-130 petition for your spouse and your spouse is here in the United States and they are eligible for adjustment of status, that means they can apply for the green card because they're here in the United States. You made a mistake that thousands upon thousands of people make. So call us. if that's the case. And you know, you might think it's a little mistake, right? And you might think that you just save a bunch of money because you didn't hire an immigration lawyer. But just imagine that if you concurrently filed your I-130 petition with your green card application, with a work authorization application, and your spouse was able to work in 6 to 8 months, as opposed to waiting 2 years before USCIS approved this petition, what is the cost? What did you lose there?
Mhm.
Right? That's over a year and a half of making money. So should we get a calculator? We're not going to get a calculator out this time because I have been very obnoxious and gotten a calculator out.
Mhm.
But I mean, we're talking about at the minimum $30,000, right? For a year and a half of
I
work.
don't need a calculator.
John doesn't need a
I got
calculator.
pen and
So,
paper here.
so we're doing minimum wage, whatever. Anyway, it doesn't matter. It's a big mistake that people make. And when you make that kind of mistake, not only are you losing out financially because your spouse could be working, but you're also putting your spouse in jeopardy because your spouse has no status. Because you thought you could read the I-130 petition instructions and be good, and you filed it. But your spouse is here, they entered with inspection, you are a U.S. citizen, and that person is eligible for adjustment of status. So I'm lecturing at this point.
Yeah.
I'm lecturing.
Yes.
I'm so sorry. I thought I could hear my kids in the back of my head right now, but it because I've seen bad things happen, right? When they shouldn't have happened, and the bad thing is getting put into removal proceedings because a 45 was not filed. Yes, okay, I'm done. I'm
No,
finished.
that's good. Everybody needs to hear this. I mean, you know, you think you're saving some money, but immigration is complicated, and the wait times are long. So when you make mistakes, they're lengthy, costly mistakes, and sometimes they're fatal mistakes. Sometimes you can absolutely destroy your case permanently, and you can't fix it. So, I mean, I think you're worth it to consult with a professional on this one.
Yeah.
All right, it's
yes.
totally worth it.
And I'll get Odette's perspective here. I mean, Odette, you worked InfoPass.
I did for many years.
You worked InfoPass. Everybody had to work InfoPass. You
Yes.
were there when people were self-filing at the window. Remember?
Yes, when they used to bring the applications in person and file.
Yes, that was my first filing in person.
Mhm.
My first officer was Lori.
And I'm sure she read you the rights
You know what? She didn't read me the rights. You know why?
because you had everything
Because
in
I had
tip-top
a
order.
great case. I had a great first case file, and she told me that too.
Oh, good.
That was so many years ago. Okay, sorry guys, we went down memory lane.
Yeah.
So Odette, can you remember anything that just? I mean, you probably saw this over and over again. Tell us what you saw as far as people just kind of messing up and jeopardizing a case. Can you pass me that, please?
They come in with their I-130. The I-130 doesn't have all the blanks filled out. I mean, something has to go in there, whether it's NA or not. They have different addresses. If you're filing an adjustment, you and your spouse should be at the same address. No signatures, didn't add children or stepchildren, didn't submit the proper documents that go with them, marriage, previous divorces, not just your last one, all of them. We get a lot of that one, especially if it's a older couple who have been married a few times and one might have been 20 years ago. And they're like, oh, I don't know where that divorce is. Well, it's not filed properly without all of them. So there's a lot of scenarios that they've had. And I will say that I think I've seen almost all of them.
Yep.
Yeah,
Yes.
incomplete information.
Incomplete.
That is a real problem that self-filers have.
And a red
Yeah.
flag for you guys too. So
It was. And it was good that we had InfoPass back then and they could file because we could let them know right then and there. But we don't have the InfoPass where they can file the application in person anymore. So a lot of
yes.
people do it on their own and wing it.
Right. Yeah. And I think there's a good amount of people who still think they can just go walk up to your immigration office to the immigration
There
office,
is.
just get turned away by the security guards.
That's true.
Yeah. You have to have an appointment, and you definitely can't be filing any application there. They don't take your cash or your check
No,
anymore.
no, nope.
Yeah, or money order. Okay, somebody's asking here on Facebook, I'm from the Philippines. Can you do consular processing? 100% consular processing all day long.
And then, did you get to the one before that?
Oh, no, yeah, Leah.
It's kind of an incomplete question. I
Yeah.
want to get my son. He's married. How long to get him?
A long time, a very long time. Leah Elibi. I'll put that question up. I don't want to. Odette, can you see questions on the screen? No.
Not on Facebook. No.
Okay. So, okay, let's just guess that Leia is from the Philippines. Leia is kind of a Filipino name. So, the question is, she wants to petition for her son. He's married. So, number one, you have to be a U.S. citizen. So, let's just assume you are a U.S. citizen, right? Permanent residents can only petition for their spouses and unmarried children. And guys, permanent residents out there, it does not matter how old that child is. They just have to be unmarried. Okay. So I just happen to have the visa bulletin here. This is going to be the third preference category, guessing Philippines. Oh, I don't even know why I took this question. Do you want to read that?
Mm-mm.
It's like 20 and a half years. So there could be other ways for your son to immigrate to the United States. If you are Filipino, there is the E2 visa, investment visa, investor's visa. What about your your son's spouse? Maybe there are ways for her to immigrate that's shorter, but it's a very, very long route. Now, if you've already filed a petition for him as a, no, never mind. Take that back.
You could have facts wrong. We're assuming certain things in that answer. So,
Yep. So, Miss Leia, if you'd like to get some more information on that, please give us a call. Our initial consultation fee is $295. We credit that to your legal fees if we can help you. So give us a call.
yeah. And one thing I do want to throw out, just to add on to that, is that even when you hear a number like that, that time will come. Like, the time will pass.
Yeah.
20 years will actually arrive at some point. In fact, not some point, 20 years from now. So, we always tell people, when they see a big number, they think, never mind. Well, no, not never mind. Just, you still should do it. Just know that it's going to take a while, but it will come around.
That's
Also, that Visa Bulletin number does change. So something may dramatically happen and it goes a little bit faster.
Yes.
right. I mean, let's say there are country bans, but not the Philippines, right? Or even country bans that are, let's just say there are 20 country bans, 20 bans that are countries that are banned. It does make things move faster. I mean, that is one thing, right? I mean, it's not good. It's not a good thing. I'm not, advocating for that at all, but it can make other countries' visa bulletin numbers better and faster. So, okay.
All righty.
Okay, we only have a couple more minutes here, but let's grab a.
Yeah, we had a question on TikTok. Hi, I have an asylum approval and I applied for my green card, but I didn't receive any update.
So again, if you received a receipt notice, you can track that by going on to your USCIS account, or you can even just plug your receipt number into the case status information. And you also have to look online to see, you have to look to see the processing times of your I-485 based on that particular designation. So it's not going to be fast. I mean, it's taking here in Norfolk, I believe the posted times are 20 months for a marriage-based adjustment case. I don't know about an asylum-based adjustment case. So, it's going to take some time. You have to, if you just filed it, I would take a look at your processing times and try not to panic based on your processing times. I mean, if it was supposed to be approved a year ago, then yes, then you can maybe get some make an appointment and see what can be done about that, or do a congressional inquiry. But if you just filed it, you're probably good.
All right. It is 8:45. You want to take one more question?
Sure. One more question.
Last question. Mars
Last
wants
question.
to know, my son graduated with a master's in IT. He's on his second year OPT. What can he do to get his green card?
Mars, he should call us, and there could be possibility that if he has an employer that's willing to petition for him, that's a possibility. He could possibly self petition if he's a person of extraordinary ability, or maybe he falls under the national interest waiver. So there are other possibilities. He just needs to give us a call and let us help him figure that out if there's something there.
All right. Good luck, Mars. We will be waiting to hear from you tomorrow. All right.
All right.
Okay, everyone. Thank you so much for joining us. We do this every Wednesday at 8 o'clock. So come back next week at 8 o'clock. I'll be here. Radlin will be here. Odette will be here, I hope.
Yep.
And Odette, thank you again for joining us. It's like I said, it's always a pleasure to have you. It's always better when you're here. And
Thank you.
Thanks for bringing all your wonderful insights. We really appreciate it.
Yep. Absolutely.
All right, everyone. Two thumbs up, everyone.
2 thumbs up.
Have a really great night, everyone.
Bye.
Take care.
Thank you, guys. Bye-bye.
Bye.